I want to commend the distinguished Majority Leader and the gentleman from Wisconsin, Mr. Sensenbrenner, as well as the Chairman of the Judiciary Committee and the Chairman of the Education and Labor Committee for their leadership on this important legislation. This bill would help to restore the Americans with Disabilities Act to its rightful place among this nation's great civil rights laws. The legislation is long overdue. Countless Americans with disabilities have already been deprived of the opportunity to prove that they have been victims of discrimination, that they are qualified for a job, or that a reasonable accommodation would afford them an opportunity to participate fully at work and in community life. This bill fixes the absurd catch-22 created by the Supreme Court, in which an individual can face discrimination on the basis of an actual past or perceived disability and yet not be considered sufficiently disabled to be protected against that discrimination by the ADA. That was never Congress's intent, and this bill cures this problem. Some of my colleagues from across the aisle have raised concerns that this bill might cover minor or trivial conditions. They worry about covering stomach aches, the common cold, mild seasonal allergies, or even a hangnail. I have yet to see a case where the ADA covered an individual with a hangnail, but I've seen scores of cases where the ADA was construed not to cover individuals with cancer, epilepsy, diabetes, severe intellectual impairment, HIV, muscular dystrophy, and multiple sclerosis. These people have too often been excluded because their impairment, however serious or debilitating, was mischaracterized by the courts as temporary or its impact considered too short-lived and not permanent enough. That's what happened to Marianne Pimentel, a nurse with breast cancer who challenged her employer's failure to rehire her into her position when she returned from treatment. Ms. Pimentel was told by the courts that her cancer was not a disability, that she was not covered by the ADA. The court recognized that, quote, there's no question that her cancer has dramatically affected her life and that the associated impairment has been real and extraordinarily difficult for her and her family, unquote. Yet the court still denied her coverage because it characterized the impact of her cancer as short-lived, meaning that it, quote, did not have a substantial and lasting effect on her, unquote. But Marianne Pimentel died as a result of her breast cancer 4 months after the court issues its decision. I'm sure that her husband and 2 children disagree with the court that her cancer was short-lived and not sufficiently permanent. This bill ensures that individuals like Marianne Pimentel are covered by the law when they need it. The bill requires the courts and the federal agencies providing expert guidance to lower the burden for obtaining coverage under this landmark civil rights law. This new standard is not onerous. It is meant to reduce needless litigation over the threshold question of coverage. It's our sincere hope that with the passage of this bill, we will finally be able to focus on the important questions. Is an individual qualified? Might a reasonable accommodation afford that person the same opportunities that his or her neighbors enjoy? I therefore urge my colleagues to join me in voting for passage of H.R. 3195, as reported unanimously by the Judiciary Committee. I thank everyone associated with this passage. I yield back the balance of my time.